Trollian, Robert Pratt Patrick Trollian Jr., 24B147123. Okay, I'm gonna need a probation violation. In fact, why don't you hand a stack of those, about 5 of them or so. Good morning, sir. Your name?
Robert Trollian.
All right, so you are in here on a violation of probation. I'm going to arraign you, and we will go from there, okay?
Yes.
It is alleged that you did, first of all, I placed you on probation on February 6th of 25. And the charge was operating on impaired, and I have a charge alleging that you failed to refrain from consuming alcohol or drugs. Sadie. I don't know if they did the. All right. Failed to refrain from consuming alcohol or drugs. I think you tested positive on November 11 for a cocaine metabolite. That is the charge. If you plead guilty, or if you're found guilty, you could be incarcerated for a period of 5 days. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here?
Yes.
If you plead guilty, you'll be giving up all the rights on that advice of rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You have the right to a lawyer. I'll be happy to provide you with one if you want.
I'm an attorney, Your Honor. I just want to get this all out of me.
Okay, just slow down. Slow down. I'm just telling you, you have the right to a lawyer.
Yes.
If you want one, I will give you one. If you want to go retain your other lawyer, you can do that. Do you understand that?
Yes.
All right. You want a lawyer to represent you.
No.
To the charge that you failed to refrain from consuming alcohol or drugs testing positive for a cocaine metabolite on a chemical test of November 11 of 25. How do you plead?
Your Honor, I'm going to plead guilty to it because it said, I said to the lab, it wasn't that I went out and did.
Hang on a second. Slow down. Just slow down. I just either need a guilty plea or a not guilty plea.
Guilty.
Did you consume a cocaine metabolite within a week prior to that?
No, sir, but I was taking.
Did you do that or not?
I did not ingest cocaine, no.
You didn't have anything that had a cocaine metabolite? Well,
No, sir.
I can't take your plea then. I'll enter a not guilty plea and we'll set it for a revocation hearing. I can't take a guilty plea unless you did something wrong. Our system's better than that, right? It should be. It's gonna be in here. So I'll give you a new date and you can come back and we'll have a hearing. In fact, John, why don't you call in Jessica right now, please? Morning, gentlemen.
No.
All right. Give me 1 second. I'll get probation in here, okay? Okay. All right. Okay. Good morning, Ms. O'Donnell.
Good.
Good, you? Good. Your name?
Jessica.
So he's pleading not guilt. He's pleading guilty, but then he tells me he didn't ingest anything. I'm gonna give him time to go get a lawyer. Do you have any further information? Can you tell me what the lab said?
The lab came back, let's see. The lab came back as the cocaine metabolite and it came back at 303.
And remind me, the cutoff on that.
The cutoff is technically, let me see, 100.
So, okay. All right. So I can just, we can do one of two things. You can either have a hearing today, or I'll have you come back, allow you to go get an attorney. It's up to you. But I can't take a plea if you don't think you did anything wrong. It's not fair.
You do the hearing right up to this.
I can do it right now.
Still.
You still wish to waive your right to a lawyer?
Sure.
Raise your right hand. You don't have to testify. I'll ask you after she testifies as to whether you wish to do so, okay? You have the right to remain silent. Ms. O'Donnell, you solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
All right, you can go ahead and proceed.
I have one violation, failed to refrain from consumption and/or possession of controlled substances. The defendant submitted to chemical testing on November 11th through DNA with positive results for the cocaine metabolite. The lab results came back confirmed at 303 nanograms per milliliter. As we discussed earlier, the cutoff is 100 on the above cutoff that it was considered confirmed positive through the lab.
Was this alcohol that was involved in the initial charge, or was it drugs?
I believe it was alcohol, but let me double check for you. It was alcohol, Your Honor.
Yes.
All right, now, you can testify if you so choose. If you want to, I'm going to swear you in. If you choose not to, then that silence would not be held against you. Do you understand that?
Yes.
What is your choice?
I would just like to make a statement.
Like, so I'm going to swear you in then.
Yes.
All right. Raise your right hand. Tell me swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
Okay, go ahead.
Your Honor, I was sick for 10 to 12 days in that period, and I was ingesting cold and sinus pills. After I tested positive, I called Miss O'Donnell, I let her know what happened there. After doing some research online, apparently the cold and sinus pills that I was taking came up positive for cocaine.
I know, I hear this cold medicine stuff all the time,
Yeah.
that it's not.
I did not ingest cocaine. I'm a cocaine junkie. If I wouldn't get cocaine, Your Honor, there wouldn't be one relapse. I'd be gone. I would not be here to face the charges. I would have been, I did it for 30 years. There's no way possible that I would have done it. I would have took off.
Do you have any
I'm
questions?
here to, I can't fight it. We came back from the lab. I just wanted, I've done everything under probation you asked me to do. Everything's paid. All my classes are done. And
You have any questions for him?
No, I don't.
Do you want to add something?
I mean, everything was going well for Robert. I was gonna apply him for early discharge on December 6th, and then this positive happened just prior to that. So I mean, he was gonna be eligible for early release with this positive. He is down to testing. We're only testing once a month. I've never heard, I mean, the over-the-counter medications maybe come back positive for alcohol on occasion, but again, it's always under the cutoff. I've never heard it coming back for cocaine.
I'm sorry.
tested this morning, Your Honor.
Well, I understand, but I'm sorry, I'm going to find you guilty as charged.
Okay.
I can honestly tell you, and I don't want to quarrel with you, I don't believe what you're telling me. Okay? Just so you know, just so I'm going to give you a right to a hearing, as you just had, but I don't believe you.
Okay.
Okay?
Yes.
And you're in a courtroom. So we're not in a bar. We're not on a fishing trip where we're talking about the 96-inch salmon that we caught that was only 22 inches. So that makes it more concerning that you're trying to put one over on me, to be completely candid with you. Okay? That makes it more concerning because everybody makes mistakes. I get that. I don't understand somebody coming into a courtroom, taking an oath, and then looking the judge in the eye and telling him something the judge knows not to be true. You have to take your hat off, sir. So this is not a good scenario right now. Can I see that report stream? You'd have been better off if you just told me the truth.
Tell me the truth, Your Honor. I did not use cocaine.
I didn't remember this, to be honest with you. But you just got done telling me you were in the cocaine for 30 years, right? Is that not what you said? Did I misunderstand something?
I haven't touched cocaine since May 24, 2011, Your Honor.
Here you see. All right, what do you think?
I mean.
So we had him on probation starting on February 6th. He's on probation for 20 months, so that should take it to, right.
Yeah, but if he was eligible for early release, if he loses that opportunity, he won't be eligible.
Oh, I know. Right.
And just so you know, Your Honor, he is on the lowest level of testing. We are only testing once a month as of right now.
We're gonna increase that. I didn't look closely enough. Do you have any disabilities or anything?
No, sir.
Cocaine scares me. You're to test weekly for 1 month. If you're clean, then bi-weekly. You're to pay additional costs of $75. You're to serve 1 day on the court work program and pay $35 for that. So your total here is 110. You'll test weekly for a month. If you're clean, we'll make it bi-weekly.
Yeah.
Any questions?
Yes, what do I report for the 1 day of work, Your Honor?
They're gonna explain all that to you. It's right at the courthouse here.
All right, thank you.
Good luck. Stay away from that stuff. Thank you. People against Evan E. Allen, Hunter Smith, 2W 29943 and B.
Good morning, Your Honor. To you and your staff, Attorney Maxwell Dubin, P number 86012, and you have Ms. Smith, who stands to my left, Mr. Judge.
Ebony contracts.
I'm gonna need it. Okay. All right, counsel, we've had multiple adjournments on this. She pled attempted R&O back in October of 25. She also pled to the alcohol-related charge of operating while impaired. I've given her multiple adjournments. She took great exception to the report that I read to her. I believe it was the first sentencing date where she was, I don't know if you've had a chance to review the police report?
I have, Your Honor, I've been able to review the PSI, talk to my client about this situation, be ready for CB sentencing.
You read the police report?
I'm not read the police.
You might want to read the police. You want me to give you a copy of the police report?
I would, I mean, if that's something this court wants, I mean, would you consider a week adjournment and you're going to adjust for paid or?
No, I told her last time. You can take all morning if you need it. She's asked for 4 adjournments. I mean, this is ridiculous. She's fired lawyers. She's,
No, Your Honor, as I said, I don't need to read the police report. Honestly, be ready to proceed with.
all right, good enough. So she pled to those. Have you had a chance to review the report with her?
I have, and Your Honor, if I might, my client is, as you've given her adjournment, she's pretty familiar with everything. She's filled me in with all the details. We've had a discussion that has covered everything, and we'd like to proceed if that's okay.
No, that's fine. I don't have any issue with that.
And again, also after reading the PSI and discussing with my clients, there are no additions, corrections, nor deletions that need to be made, just simple allocution.
Okay, go ahead.
And I'll just start by saying, Your Honor, my client was not trying to be difficult with this court or with anyone. This is a big deal. This is a big step into something big.
Well, it's not too big of a deal. She's had multiple convictions, right?
So I see the possession of marijuana charges.
Well, yeah, it's more than that. You kidding? I know we're going back to 06, but larceny in a building, possession of a controlled substance 09, possession of a controlled substance 10, possession of a controlled substance 15, drunken disorderly 22, domestic aggravated 22, leaving the scene of a property damage accident, disturbed the peace, and yeah, she also had the operating while impaired from 18, operating while intoxicated, it says in here. So
Understood, Your Honor. Understood.
I'm just telling you, you got your work cut out for you on this one. I don't want to blindside you. Okay?
Yeah.
So you can go ahead and proceed.
So, again, I just want this court to know that after speaking with my client, at least when she's retaining me, she's taking full responsibility for everything that happened. She's went over the details of me and how this matter came about. And I've had a good opportunity to talk to her, Your Honor. I want you to understand that I did go through her criminal history. And I have had, a discussion with her about that, and she's been very upfront and forward with me. Very, very forward.
About what happened at the scene?
The past case, Your Honor.
Okay,
everything.
good.
I want you to know she's taking full responsibility. Okay, Your Honor. She understands that she has decided in the past to now go down a path that she's much better than. My client's an entrepreneur. She has a 3D printing business. She does that, and she has every tool and opportunity to her to be very successful. And if she continues down the path she's going on, she's making a poor choice that's gonna ruin the rest of her life, when she has every opportunity to do much better than she's showing me. She has been excellent on bond, Your Honor. She's had no bond violations. I'm gonna ask this court adopt that recommendation, because I do think, Your Honor, that, with the correct help and push and guidance, she can go down and the path this court and everybody here wants her to go down, Your Honor, and improve and be better. And I know she's gonna be better. If this court just adopts the recommendation, I think the goal of the court will be met, and I think my client's gonna do better off front.
Anything you would like to say, ma'am?
I would like to apologize to the court for all the delays and that I understand my mistakes and I want to be on the road to make my life better.
I don't want you to apologize. I don't want you to apologize for the delays. I do want you to recognize that I don't appreciate you coming in here, looking me in the eye and telling me none of this happened. I can handle a lot of things. I can't stand when somebody stands there 20 feet from me, looks me in the eye and tells me something. It's untruthful. Now, if this police report is false, as you made it sound before, this officer has no business not only being a police officer, but carrying somebody's garbage across the street. You don't take on police like this. I opened my door and issued multiple commands for the driver to return to the vehicle. She immediately stated no and mentioned I would have to kill her. The driver began taunting me and verbally refusing my commands to return to her vehicle. I requested additional units and attempted a fifth and final time to order the driver to return to her vehicle. And she said, "Are you going to kill me?" No. Then what are you going to do? We don't do that. This is not a lawless country. I know some think it is, but it's not going, ma'am, look at me when I'm talking to you. We don't do that. We don't do that. Now, police are wrong sometimes. I'll be the first one to tell you that. Judges are wrong sometimes. But you don't get to do this. And your record speaks volumes about how law-abiding you've been. You can't do this. And then she berates her last court-appointed lawyer, how he didn't tell her these things, and fires him. And that's all fine and dandy, but Mr. Crawford has my utmost respect. Comes in here, works hard for people, does the best he can. But I want you to know the decision I'm going to make here, how do I say this? It's based on your record. It's based on the fact that you consistently violate laws. And that's what judges do. At least that's what this judge does. I'm going to place you on probation for 24 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume illegal controlled substances. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're going to be on a... Now, counsel, if she thinks she can get here, she lives in Warren, right? I'll take her in sobriety. I'll take her in sobriety court. She won't go to jail today. I'm going to let you, and you know what I'm going to do, just to be completely fair about this? Do you have another court you have to go to?
Exam, actually.
Okay, look.
In 36.
Look, what time does it start? Okay. Here's what I'd like you to do. Let's adjourn this week. You go down and you speak, but it's gonna take a commitment from her. She's gonna have to come here,
No sobriety for a while.
okay? And if she wants to do that, she's gonna turn her life around, and I'm gonna help her do it.
Absolutely. I appreciate that.
You wanna adjourn it a week?
I will adjourn, yeah, if we can.
You give me a date that's good for you next week. But I want you to sit down, or at least her to sit down with probation today to see whether she wants to do it. And then I would put her on a bond phase. When you guys show up next week, I would put her on a bond phase for 4 weeks. You give me a date that's good for you.
What, is Friday, do you do Fridays or not?
I do Fridays, but I'd rather not do Fridays.
Fair enough.
If that's all I have. I mean, do I have anything scheduled on any of these Fridays, Lisa, coming up?
On the 12th, is that the
You wanna
date we're
do-
looking at?
Want to do the 12th? Do I on the 12th?
Let me look.
I was looking at next Friday, next week. But I mean, I guess we could,
Hang on.
we
Let,
could do this Friday.
do I have
Nothing on
some-
nothing on the 12th or the 19th. Judge Hessen does have a jury trial on the 12th.
Okay,
I could do this Friday.
I'll do this Friday for you.
Does that work?
Absolutely.
I think that's ample time.
We'll adjourn this until, we'll make it 9 o'clock in the morning on Friday.
Perfect. I appreciate that, Aaron. Thank you for working with me.
But I'm telling you, I need her to consider sobriety court.
I'm picking up for your, I practice here a lot. I completely understand.
And if she shows me a different attitude, she and I are gonna get along great. She's gonna actually like me in 2 years, believe me.
Sure, quicker.
Go down the hall, get your notice. You're all set, man. I hope you'll consider it. All right, Mr. Ford, come on up here, sir. Dylan Randall Ford, 25G, 305-475. All right. I'm gonna need Jessica in here. Do you know her number off the top of your head?
You want me?
I'll call her. I'm gonna need Dylan Ford and yeah, and then can you tell Beth I'm gonna need her on Gregory Pugh, please?
I will let her know and I'll be right there, Joe.
Thank you. Your name? You pled guilty to all counts on November 24th. I told you I wanted you to go over and provide proof of completion of community service in an outpatient treatment. And you said you'd gone, and I owed you to test that day. So before we go on, I want to remind you, you have the right to a lawyer. I'll be happy to provide you with one at public expense if you want one. Would you like a lawyer? Did you go and test?
Yes, I did.
Were you negative? Did you get your community service done?
Yes, sir.
Did you provide proof?
Yes, she should have it.
How about your outpatient treatment?
Yes, she should have it as well.
What do you have to tell me?
I apologize for not having the responsibility. I'm trying to get yards, kind of like, that it's nice. Well, I don't ever think I have like a problem. Get that first.
Doesn't go down.
Did he test negative?
He did.
Did he provide you with proof of completion of the community service?
The community service, he didn't complete it when he was supposed to be completed at the weekend before his hearing, but all 8 hours are completed. I do have proof from a therapist, but I am concerned. The therapist stated that he only met with him twice. And that he has no future appointments scheduled. He was a no-show for 2 other appointments that they had scheduled beforehand. And the therapist states in an email to him, because I asked, do you have any future appointments? What's the game plan? The therapist stated, to be honest, that he didn't want to see him again. He stated that the defendant is not reliable. And that you only saw him twice in a 3-month span.
Mr. Ford, I didn't think I was gonna have a problem with you.
Well, he asked me if I want to see it again. I asked him, how many times do I have to see you? And he said, yeah, it's not, right, he doesn't know, so when he said, do you want to see me again? I was like, I mean, I prefer not to. And for me, it's like, I don't really think, personally, I will do it if I have to do it, but I don't think therapy's like the biggest help, you know, like. I don't think therapy.
Let me see the screening. What category did he score in?
He scored a 4 in alcohol and a 1 in drunk.
I mean, that tells us you got a problem. This wasn't based on a subjective determination that she made. 4 is the highest, second highest. 5 is the highest. It's based on your answer to the questionnaire. I mean, you're 20 years old. You had alcohol-induced blackouts. Don't push me to do something that I don't want to do, Mr. Ford. I'm telling you. I mean, come on, alcohol-induced blackouts at the ripe old age of 20. I guess you're 21 now, right?
That's more of just partying on the weekend, but I guess you'd say.
You're drinking to the point of excess if you're having blackouts. Pay additional costs of $100, serve 1 day on the court work program and pay $35 on that. You're to attend and complete outpatient treatment, and I mean that's going to happen 1 time per week. Do you understand what I'm saying to you?
That's what I would be.
Yeah. So let's get him set up on that. Let's get him set up for his court work program day. You owe $135. Can you pay that today?
Yeah.
Come on, here you go. Yeah. Oh, geez, Sadie. Sorry. 135. Pay that, get back in outpatient, do your court work. Come on. I want to double check something. I gave you 10 months probation in July. You got to get going.
How many therapy things are needed?
Outpatient treatment is essentially once a week. I want to make sure you're okay. You don't think you have a problem. I don't know what I can tell you to make you understand that no disrespect intended. We think you have a problem. You're suffering from alcohol-induced blackouts when you weren't even legally able to drink. I'm not making you out to be a bad person, but you got to take care of your business. Once a week until released by the therapist. Good luck. Pew.